Nicholas Rosenberg here. I represent Edin, Alex, Enamorado. And I'll give you the backstory. The backstory is, if you've been following this, we were in court on January 19th, and we had our first bail hearing. That was a Friday. We come to court on Fridays out here in Victorville. So we came back the following Friday on January 26th, and the judge heard the rebuttal from the prosecutor. So essentially 2 weeks later, we had a hearing set for today, and initially the judge said that he was gonna rule by minute order, in other words, not face-to-face with the community in court, and he said he would do that before February 9th, but I asked to set a court date, and so we set a backup court date for today. So we waited and waited and waited, and the court did not rule on the request to reduce bail from no bail. I asked for $80,000 cash bail, which is the bail schedule for a kidnapping, and that was an amount that my client Alex could afford, with restrictions, terms and conditions, such as do not contact the co-defendants, do not contact the alleged victims in this case, stay off social media, and any other terms and conditions that the judge saw fit. And so on the 19th, I gave a 40-minute long bail review argument, and you could tell in today's court ruling that the judge cited some of the cases and penal code sections that I cited. But today the judge did find no change in circumstances, so therefore the judge denied the bail request. So what that means is Alex and everybody else is still subject to a no bail hold. No bail hold means there is no way for them to get out. No way for Alex to get out. No way for Alex to get out, and everybody else. So I appreciate everyone who's here today in solidarity with the Justice 8. Raise a fist if you're in solidarity. I appreciate the diversity of the group that is here today. Now, I talked to Alex, and you guys know after court, I always talk to my client because I want to explain to him what's going on. And we talk about a lot of issues, but what we really talk about the most, we talk about the law. So in my practice, I try and focus on the law, not the chisme, not the drama, not the ratoncitos, not the division in the community, okay? So that's why I'm giving you the legal update first. Now I have some backstory. So remember at the last court date, Alex was in the hole. Now they call it restrictive housing. We call it administrative segregation, 23 hours out of 24 hours inside your cell. But you'll remember that Alex actually spent up to 36 hours in a 4-foot by 8-foot box. And that's because when they bring him out in the morning, if they wait until the evening the next day, he ended up spending 36 hours in the hole, basically solitary confinement, 4x8 cell with a cot and a toilet in there. No window, obviously. Okay, so he's out of the hole now, which is good, but he told me, Rosenberg, I spent 12 days in restrictive housing. That's 2 days longer than they told him he would spend. So that was a 10-day order, and he spent 12 days in the hole, okay? I don't care what the sheriff says, it's the hole. Now, I had a chance to speak to a journalist. Shout out to my boy right here, Mr. Victoria, and I actually provided him with the entire set of state of California regulations that we call Title 15. And Title 15 is the law and the rules for how to run a jail. And I encourage everyone who's tuning in, go ahead and Google California Regulation Title XV and start educating yourself about what we call conditions of confinement. Little detour. When I was in law school, I was an intern, a paid intern, at something called Prisoner Legal Services for the San Francisco Sheriff. And we actually enforced the conditions of confinement. So we were a free call for all the prisoners. They could call us, they call us PLS, Prisoner Legal Services. So I got people married, I got people divorced, I inspected the safety cells, I went to the SVPs, I went all over the jail, and I had the power to actually file a lawsuit against the sheriff. And that was my introduction to Title 15 regulations. So I encourage everyone who's here, everyone who's watching, this is your homework assignment. Please Google, please have a look at Title 15, okay? That's something that will build the community and will show support for Alex here. So I'm gonna read to you his message. I made a special point to write it down because when Alex speaks, I wanna make sure to get it exactly right. And I always give him the opportunity to tell me, what does he want me to tell the people? What does he want me to tell the comunidad? Okay? So Alex's message is this: I am not surprised by today's ruling, but this continues to prove San Bernardino County's corruption. Corrupción. We are facing similar charges to what prominent activists faced in the 1960s. Please pray for Wendy, who is being targeted inside the jail and has now been sent back to the hole again for another 10 days. The East LA 13 and the Black Panthers in the 1960s had worse drama. And this is why they arrested 8 of us to create chaos. But drama is also a way of grieving, because this is a tragedy and this is an injustice. Yeah. I asked him, what do you want street vendors to know? And he said, street vendors are still not alone. That's right. Street vendors are still not alone. Street vendors are still not alone. Street vendors are still not alone.
Los vendedores no están solos.
And we love them and we miss them. So now I'm gonna give you guys a summary of the conditions that Alex has been experiencing. And some of this, I had to get attorney-client permission because this is intimate details about his physical health. So if you know, now you know. If you don't know, now you know, Biggie Smalls. Alex had a treatment for colon cancer. And ever since that treatment, he's had bleeding, okay? This happened during the preliminary hearing. I had to ask the judge to have him uncuff his hand when he went to the bathroom, and the judge approved that order. But then the deputies stopped following that order during the preliminary hearing. Now, if that's not a Title 15 issue, Google it and report back to me. So Alex has been having bleeding. So he's been requesting the gastrointestinal specialist for basic remedial treatment because he's bleeding. And if you know, if bleeding goes untreated, you can actually faint. If bleeding goes untreated, you can lose consciousness, and it's possible that there are health repercussions. So Alex is not getting the treatment that he deserves for a valid medical reason. Now, he told me that the next day after he requested to see the gastrointestinal specialist, that they only brought him to the general medical doctor. And the general medical doctor told him, Mr. Enamorado, you will never see a specialist. You will never see a specialist because you requested spicy food in December, and that's why you have acid. And I asked Alex, did you explain to the doctor what your presenting medical condition was? And he says, yes, Rosenberg. I told him I'm here for internal bleeding. So as of right now, Alex has yet to see a gastrointestinal specialist. So I'm asking everyone who's here, everyone who is tuning in, to please write a letter to the jail. We'll get you the address, the information. Usually I target things like this to what we call the watch commander. Alex is at the High Desert Detention Facility, but let's raise some awareness about this issue. Now, some of you may be saying, well, Rosenberg, you're the lawyer. What are you gonna do? And one of the things I'm doing is raising the awareness because I just found out today myself, okay? That's why I talk to my client when I go to court, because my client teaches me things. My client instructs me on things. My client is a very smart, highly functioning person. My client is a leader. Now, the reason why I'm an effective lawyer is because I listen to my clients, okay? So I'm gonna circle back with Christian Contreras. He's a civil rights attorney, and he's the kind of lawyer that can enforce Title 15. I'm gonna give a shout out to my compañero, MrCheckpoint. He's the homie.
Yes, sir.
He's what we would call a cam,
A good ally.
camarada, and he's in touch with many civil rights attorneys. So we're not just gonna take this lying down, okay? We're gonna do what I end all my speeches with. We're gonna be punching back. But I want the community to get involved because a lawyer is a lawyer because of the power of the community. So when you see the lawyer, behind the lawyer is an entire community of supporters, of activists, of family members, of clients, supporters, friends, and family. So I don't stand here alone as the attorney for Alex. I'm here with you, and it's gonna be you, the pueblo, the comunidad, that's going to help Alex, because it's really your power that a lawyer taps into. So I want you to know that that's really how I feel about this case. Now you may say, Rosenberg, how come you only talk about Alex? And the reason why I only talk about Alex is he's my client. But everything that I say about Alex is applicable to the other 6 who are also being held on a no bail hold. It's just that Alex is the leader of this movement, so I focus on Alex. Now, as I've said many times before, I'm not here for the clout. I'm just trying to get Alex out. And the problem is that today was our last opportunity to have the judge modify the no bail order. And so what that means is that now we have to go to the Court of Appeals. Now, the judge said something that was actually very interesting when he was talking about In re Alberto, which is the case that I cited regarding change of circumstances for the defendant or the proceedings. And if you were at that bail hearing, you know that I argued the filing of the information, the charging document after preliminary hearing, is a change in the proceedings. So when the judge denied the change in circumstances, he took the easy way out to say Rosenberg, Alex will have no bail. But he said something interesting. He said, now and I'm speaking as the judge, when the judge read In re Alberto, that case provided that an error by the second judge is not reviewed by the first judge. It's reviewed for extraordinary relief. And what that means is a writ of habeas corpus to the Court of Appeals. So what I'm trying to tell you is the judge basically invited Rosenberg to take up a writ to challenge his ruling. Now that's my interpretation. That's what my legal training and experience as a criminal attorney for 18 years, that's what the judge really told me. And so if you remember at the last hearing, I asked the judge for a transcript of all of the bail proceedings at court expense. And if you remember, the judge said, Rosenberg, I've never had a private attorney ask for a transcript at court expense. And he said, give me 24 hours and I'll get back to you. Well, he never did. So today I renewed my request and I said, Your Honor, there's a case called In re Tran, and that case stands for, and the judge said, Mr. Rosenberg, let me interrupt you. Your request is granted. So the judge knows that we are going to seek, we say relief. What does that mean? Relief means get a remedy, get another set of judges to look at what happened and decide if the Court of Appeals is going to say, you know what, we're going to reverse that no bail hold and we're going to go ahead and remand, send the case back to the judge for proceedings consistent with our ruling, which basically means give these people bail with ankle monitor, house arrest, and conditions. Now, it's certainly not guaranteed, but it is the next step in the fight.
Are you going to appeal?
Yeah, that's what I've said. Okay. We're taking out a writ.
All right.
Come on, man, it's English.
You said you could.
No, I'm just messing with you, homie.
All right.
Okay, so the other thing I want to bring out is that the judge made findings of fact and he made findings of law, but if you remember, he never brought up what I brought up at the end, which is that I said, Your Honor, does the court have a position on when Judge Rodriguez released Gulet Jaguar Acevedo with strict terms and conditions, including stay off the internet, no contact with the alleged victims, and no contact with the co-defendants. And he said, Mr. Rosenberg, I'm glad you brought that up. Okay? But his ruling remains the same. No change in circumstances. So what no change in circumstances means is as a threshold matter, as an initial matter, we got smacked down. That means the judge never had to reach the issue of whether there are less restrictive means, terms and conditions to guarantee Alex's appearance at court, protect the public safety, and protect the safety of the alleged victims. So that is the update. I hope that you found it informative. helpful, insightful, and most of all, inspiring. The next court date remains March 1st. That's for a pretrial. And in the meantime, I'm going to circle back with the lawyers. My intention is to, because we're going to do a bunch of motions here. Okay, we have to challenge jurisdiction, venue. We're going to do pitches motions on the cops. A pitches motion means that we're telling the judge we have a right to have the personnel files of a police officer inspected, and we want the names of people who have accused these officers of misconduct. That's called a pitches motion. Google it if you're interested. It used to be very hard for us defense lawyers. They used to put up a lot of obstacles and roadblocks. Now the case law and the statutes are a little bit more on our side. So when I say statutes, what do I mean? I mean Penal Code Section 1289 is what we call a statute, okay? Case law means the law that is decisional law that is made by a case, and I mentioned the case of In Re Alberto. So if you're interested, for extra credit for your homework, Google a pitches motion, because remember, this is about the community, this is about street vendors, this is about the First Amendment, but it's also about the criminal justice system. So I invite you to do what you've been doing, which is participate. I invite you to jury duty. I invite you to Google. I invite you to get more invested in this criminal justice system, which has the power to take away somebody's liberty. And in the United States, it's not perfect, but I'm still a believer. I'm still a believer in our system because I've been to China. I've been to the Philippines. I've been to Colombia. And I have seen the way these other governments operate. But having said that I'm a believer, by no means am I saying that our criminal justice system is perfect. So if you want to change the criminal justice system, keep doing what you're doing. Participate, show up, educate, get educated, get motivated, and most importantly, start a movement from this moment forward, reclaiming your power. All right, guys, in solidarity, thanks very much, and I appreciate that. Yes, Kalui. Did I say it right? Say it? Quali. Okay, Quali. Lo siento.
Regarding the discovery of the emails and the text messages of Mayor Aquanera from Fontana and those the attorney previously, the one that stepped out, Alimouri, he said that you guys are all in consensus about trying to get those emails and text messages discovered so that you guys can see what they are communicating with each other, because they are all like friends and know each other. And then
Sure.
Mayor Aquanera is a witness in the protest at her house, and she's like a conflict of interest, yet she's a witness.
So what I'm going to do is I'm going to answer from the law first, and then I'll let you draw your own conclusions. Okay. So in California, we can make what we call an informal discovery request under Penal Code Section 1054.1. And once we make an informal discovery request, informal means I can send an email or I can write a letter, but it's not a motion in front of a judge. So when we make an informal discovery request, the prosecution has 15 days from that date to comply and get us the requested evidence, unless there's an evidentiary privilege being sought, like an ongoing investigation. If they fail to do so, we then have the right to appear in court and file a discovery motion and ask the judge to order them to furnish the requested evidence. So those are the legal standards at play. Now, Mr. Alimouri has made that request. I myself have joined in that request. I'm not looking to start World War III with Fontana. Mr. Contreras and my client have already filed a lawsuit challenging what that jurisdiction has done regarding the street vendors. So as of right now, I do not have a response to that discovery request.
I have a question. Did Alex expand more on why Wendy is being targeted inside the jail?
He did. So what happened, this is what he said. He said that Wendy had no money on her books and she used somebody else's PIN number to make a phone call to her special needs adult daughter, who, if you remember from my bail motion, has cerebral palsy, epilepsy, and is actually blind. So she made that phone call, and Alex said, Rosenberg, people swap pins in the jail all the time, okay? And he said that was the basis for why he said she's being targeted in the jail and sent back to the hole. So basically, I'm gonna use some of the homie slang, okay? When you're in the Justice 8, you best be running a squeaky clean program, because if not, this is what is going to happen, okay? All right, guys, thanks. Solidarity, as they say, much love.
I'll be totally honest, and I entirely expected that. I'm a realist when it comes to this system. I've been doing this for close to 10 years, and I understand the way in which the system is biased, the way in which the system is prejudiced, the way in which the system operates. Quite frankly, the fact that the decision was postponed for 2 weeks flies in the concept of liberating these folks, right? If the judge was inclined to liberate them on bail, then he wouldn't have delayed his decision for 2 weeks. Now, why did we come back 2 weeks after the fact when we only came to hear a denial? Something which could have been communicated to us via email, something which could have been posted on the court website. What was the point of bringing us back for a denial that lasted, 5 minutes or so? What was the point of that? Was that to make a point to the public that they are going to do what they want to do, regardless of whether or not you're opposed to it? Was that to make a point that they're in charge? The fact of the matter is, and I will say this, I'm angry at the decision, but at the same time I totally expected it, not because of the conduct of my client, not because of the conduct of any of the defendants in this case, but because of the way in which this system has revealed itself to us, the way in which it's been operating thus far. It's laid a precedent to us from the outset that they will give no concessions to these individuals who are charged in this case, including my client. And what does that mean? That means that we have to put up a fight in defense in this court of law. And that's precisely what I intend to do. That's precisely what my colleagues intend to do. And the fact of the matter is, we will put up a fight against these unjust charges, against this draconian display of authority and power, whereby folks who have done nothing are in jail with no bail, while folks who go out and commit real crimes like murder, like attempted murder, like rape, are given money bail. So this speaks volumes about the essence of the system that's pitted against these individuals who have stood up for the rights of disenfranchised folks, of street vendors, of undocumented people, of folks who are brutalized by the very system that is now attempting to brutalize them in court. By what? By incarcerating them with no bail, something which the 8th Amendment of the U.S. Constitution entitles them to. Last I remember, we have the right to bail in a court of law in this country. Last I remember, we have the right to due process of law in a court of law. So my job and the job of the defense attorneys in this case is to put the system to that test on behalf of these individuals. The test of the right to due process, the test of the presumption of innocence, the test of the right to bail. Practice what you preach. The system's about due process, the system's about the right to bail, then practice what you preach. And we're here to make sure that that is put into practice. And what I will say in line with that, I have already sent an informal request to the prosecutors in this case via email, requesting that they turn over all communications between the mayor of Fontana, the sheriff's department, the Pomona Police Department, as well as the district attorney's office in relation to this investigation and this case. Why? Because the mayor apparently is a witness in that they referred to the protest in front of her home at the preliminary hearing, as you might recall. So guess what? That makes her a witness. So anything she has to say to law enforcement, to the Pomona Police Department, particularly to the Sheriff's Department, to the DA's office, is discoverable under the Penal Code and under the 14th Amendment of the U.S. Constitution. Now, I emailed them 2 days ago, or 3 days ago. I have yet to hear back from them. All the other attorneys joined in my request via email. We've yet to hear back from them in that regard. I imagine, based on the way things are going right now, that they're either going to ignore my request or they're going to just say, no, you don't get that stuff. So, fine. I'll bring a motion in court and we'll argue that before the judge, and then we'll have the judge decide whether we're entitled to the communications between the mayor, who is supposedly a public servant, who happens to be a witness in this case, the DA's office, the Pomona Police Department, and the Sheriff's Department. Now let's see whether they're willing to come to court and say in a public forum that no, ladies and gentlemen, no, you don't get that stuff. No, you don't get to hear about what we chatted about before we incarcerated Mr. Enamorado, Ms. Carrasco, and all the other individuals in here. So my job is to put them to the test, to make them practice what they preach. That's all I'm saying. Practice what you preach. You talk about civil rights, you talk about the Bill of Rights, you talk about the land of the free, home of the brave, you talk about we have the best system in the world, then practice what you preach. Come on, let's see it. Let's see it. Hold on 1 second. And the beautiful thing that we have in this system, and that we still have, is the right to jury trial. To have this case in front of a jury of regular average people, not politicians, not judges who are appointed by the governor, not individuals who are elected by folks who have prejudices against people who are charged with crimes, I should say. So we still have that right to jury trial in this system, and we're anticipating a trial that will ultimately vindicate our clients, and my client in particular, Ms. Carrasco, and I'll speak about her in particular. She had absolutely nothing to do with any of this. She was only there by their argument, and that's it. Is that enough to convict somebody of conspiracy? To convict somebody of being part and parcel of some sort of an organized crime? No, it's not. All right.
No.
Yeah. So, if you have any questions, feel free to ask.
What did the judge mean by change of circumstance?
So under the law, in order to ask for bail reduction in the middle of the case, the defense must establish that there has been what is called a change of circumstances, that something substantive has changed in the case that would justify bringing up the issue again to the court, the issue of bail. He claimed that there was no change in circumstances. Now, our argument is that clearly there was a change in circumstances. The judge, quite frankly, dismissed a few of the counts in relation to all of these individuals. So, if that's the case, that's a change in circumstances. The fact of the matter is we had a legal basis to ask for bail reduction. He's claiming we didn't. Something we'll take up on appeal. We'll let the Court of Appeals decide.
In this letter you sent regarding the conversations between the mayor and so forth. Who did you send that to?
I sent that to John Richardson, the deputy district attorney, with whom I've been in contact throughout this case and who's been in court advocating on behalf of the government.
How long do they have to respond to you? I mean, is this like a California
Under the law, they have 15 days from the date of my request to respond to my request, and if they don't respond within 15 days, then I can file a motion to compel. But that's with respect to the penal code. Under the 14th Amendment of the U.S. Constitution, we're entitled to any exculpatory information that they have in their possession, right? Because prosecutors are not supposed to seek out convictions at all costs. They're supposed to ensure that the guilty are convicted and the innocent go free. So this isn't a game of them hiding evidence so as to win a conviction, right? This is supposed to be a system in which they turn over stuff that will help the defense, right? This isn't a game in which they can hide stuff so that they can get a conviction at all costs. So I'm putting their feet to the fire and I'm asking them to turn over that which I believe sincerely is constitutionally mandated under the 14th Amendment and the presumption of innocence.
What other constitutional violations do you see here, sir?
I see a violation of the right to bail. I see a violation of the right to due process. I see potentially the violation of the right to a fair trial. Why is the sheriff of San Bernardino County going, while this case is pending, on the local news and giving interviews about this case? For what? To taint a potential jury so as to deprive these folks of their rights under the 6th Amendment and the 14th Amendment? The 6th Amendment guarantees a fair trial. The 14th Amendment guarantees due process of law. You should know better than that. The case is pending and he's making public statements in relation to it.
What do you make of 10 deputies being present in the courtroom?
That's indicative of the violation of due process against these individuals. Who are these people in their minds? Are they terrorists? Are they members of ISIS or Hamas or something to that effect that require all that? Are they afraid of the folks in the audience?
Attorney, I wanted to ask you specifically about that. At the end, they said that whatever we're doing here is actually like affecting the court. ¿Cuál es tu opinión sobre la forma en que la corte está diciendo sobre que los activistas usando el primer mandamiento de la Constitución es ilegal? What's your opinion on that?
My opinion is that they're not used to having the people in court. They're not used to having the people in court advocating for defendants to this extent. And what they want to do is make sure that everyone in court stays in line, and by saying stays in line, I mean follows everything that they say to a T, even if it's arbitrary and prejudicial and indicative of a violation of your rights to observe all this stuff as members of this state, this country, as citizens of this country, as inhabitants of this country who have rights under the U.S. Constitution and the law.
I was harassed for bringing a camera and giving this picture.
Right. So that's wrong. You have the right, if you are a journalist, to provide them that documentation, to seek out that sort of accommodation to film or to be able to record.
Seeing everything that we've been seeing in Victorville, for example, the first arraignment, they hit them. They weren't on the docket. They weren't on calendar. I don't think that they were going to have a fair trial here. You can answer, are you guys planning to move venue or change venue?
We're planning on changing venue. That's something that everybody knows. The prosecutors know that. The judges know that we're going to file a motion in that regard eventually. Do I think that they'll grant the motion? No. Do I think that they'll allow us to shift this over to LA County? No, I don't. Because I'm a realist and I know the way in which the system operates. I know in which the way in which the judges operate. The true hope, the shining hope, the beauty of the system in place is the fact that we can have this jury hear this stuff, and a jury consists of regular, average, ordinary people, not politicians who work for the district attorney's office, not judges, not other bureaucrats, but rather everyday, average, ordinary people. And I have faith in the people of San Bernardino County just as well as I do in the people of Los Angeles County, or any other county for that matter.
So do we need people to attend
Yes.
the courts and to share the media?
100%. Yes. Yes.
Should people be saying that we shouldn't be doing that online? Because I've heard some people say that they don't want to jump on the bandwagon, which is ridiculous.
No. You have a right to free speech.
Right.
I'm advocating non-violent demonstration. I'm advocating non-violent public displays of support because that's protected under the First Amendment of the U.S. Constitution.
Thanks for the book.
Given the fact that the DA is giving interviews to people and potentially
The Sheriff's
tainting-
Department.
Oh,
Yes.
okay. Yes, that they're giving interviews and potentially tainting what the public would view as a fair trial. Is that something you can argue to change the venue and go
course.
somewhere where the public hasn't already been pre-exposed and
course.
potentially tainted?
Of course, that's one of the central arguments that would be made in that regard. Of course. That's highly prejudicial. So that's, unless there's any, I can take one more question, then I gotta head out. No?
What can we expect on the month?
I have a ton of motions I intend to file. On behalf of Ms. Carrasco, I intend to file a motion to dismiss for insufficient evidence. I intend to file a motion to dismiss on constitutional grounds. I intend to file a Racial Justice Act motion. The argument would be that this prosecution is racist at its core. The California legislature just passed a law that allows defendants to seek dismissals on the basis of claims of racism. That's a new law, so I'm going to implement that in the course of the litigation of this case. Again, I'm going to file motions for discovery, particularly with respect to the stuff concerning the conversations between public officials and the DA's office. And by the way, the district attorney is also a public servant. All the deputy prosecutors in court are public servants, right? They say they're on behalf of the people, right? They represent the people, okay? But I refer to them as prosecutors and representatives of the government in actuality. They can say that they're representatives of the people, but I certainly don't see any people here asking for the Justice Aid to remain in jail.
Damon, when do we need to show up?
The next court date is the 1st of March,
What time?
8:30 in the morning for now, unless
really?
something changes, okay?
When would you
Alrighty.
be planning to move are you planning to move the hearing somewhere else due to the fact that there's discrimination?
We're going to file a motion in that regard.
This is why we always
Film police.
film.
Subscribe to Mr. Checkpoint on YouTube and send your cop videos to MrCheckpoint.com/submit.